I mean, I think the other thing that the former prime minister speaks to is the brazenness with which Trump, he was talking in that interview about his disdain for Angela Merkel and his infatuation and admiration and affection. He called it creepy, the way he acted around Putin. Let me show you how the natural extension of that is that all this behavior and all this conduct, the mishandling of classified documents, happened on tape in an interview. Let me play some of that.
Well, with Milley, let me see that. I'll show you an example. He said that I wanted to attack Iran. Isn't it amazing? I have a big pile of papers. This thing just came up. Look. This was him. They presented me this. This is off the record, but they presented me this. This was him. This was the Defense Department and him. Wow. We looked at him. This was him. This wasn't done by me. This was him. All sorts of stuff. It's pages long. Look. Wait a minute. Let's see here. These are the papers. This was done by the military, given to me. I think we can probably get it.
I don't know. We'll have to see. Yeah, we'll have to try to figure out a yeah.
See, as president, I could have declassified it. Now I can't, but this is classified.
No.
So, Mary, the consequences are catastrophic to the world order. The evidence is smoking gun, basic confessions on tape, waving things around. How are we in this position that we're in today?
Yeah, so, you ask, why are we worried that this case might not get to trial? And a lot of that, frankly, has to do with the judge assigned to this, Judge Aileen Cannon. I mean, at every turn, she has been overly solicitous, I think, to put it mildly, toward Mr. Trump and his arguments, including, viewers will recall, before she even had been assigned to the criminal case. Because at the point of time where there had just been a search warrant executed, Mr. Trump went in and brought a civil case that got assigned to Judge Cannon to try to prevent the Department of Justice from reviewing the classified materials, not only for purposes of their criminal case, but also for purposes of doing an intelligence review to find out how much damage had been done to our national security. He went into court to try to prevent the department from doing that, and she sided with him. Now, she was reversed by the 11th Circuit, and then ultimately, when the criminal case was actually brought, the indictment brought, lo and behold, of course, that case went to her. And Jack Smith knew that wasn't a chance because she's in a district with just a few judges. And so there were decent odds she would get it. But my point is, even since before the case was in front of her, she's really, really given Mr. Trump a huge amount of leeway in terms of his arguments and arguments that he accepted. She spent a couple of months considering SEPA Section 4 motions. These are motions under the Classified Information Procedures Act that are normally and routinely ex parte, under seal. That means just the government and the judge, without them being available to the public or, frankly, even to the defense attorney, where the department can go to the judge and say, here are documents that we think we need to provide to the defendant in discovery, but here are things that we think we need to redact or substitute because of their high sensitivity. She drugged that process out for so long that that's one of the reasons that we're now delayed. Remember, this case was supposed to go to trial May 20th. So I am encouraged by some of her recent rulings, such as denying the defense request to see everything that the government submitted with respect to that SEPA Section 4 motion. But, we have to be worried about how she will rule on some of the motions that now have been filed by the former president, including a motion that he should be immune from prosecution because he made decisions to allegedly made decisions to designate classified information as personal property while he was still president. Therefore, his argument is, because I was president at that time, this is within the scope of my official acts, and I'm immune. Now, never mind that it's ridiculous to suggest you could designate classified information as personal, but this is the kind of argument that may get some traction with this judge. And so I think we have to be worried about that. I don't know whether it's bad faith or just just not, or just a lack of experience as a judge, and certainly a lack of experience working with classified information or national security cases. But it's very troublesome. And you know, Brandon is exactly right. The harm is not just limited to the potential actual harms from programs and sources and methods that we may need to change because of all these documents that we don't know who they may have been shared with at Mar-a-Lago, or when where Mr. Trump is trying, because he's mad at General Milley, trying to share documents with you know, biographers just because he wants to, not even for any legitimate purpose, but just because he's mad at General Milley. I mean, not only is the damage done from all that, but our allies, as the former prime minister said, you know, they see this. They see Mr. Trump standing in the polls right now and the potential that he could actually become the president again. They put that together with things that he's been saying recently about Putin, about NATO, and that's just terrifying to the rest of our allies and partners. And I think the potential risk to our national security is extremely grave.
You know, I think, David Jolly, at this point, I mean, I joked in the last block about feeling like I came back and it's that scene, and while you were sleeping, what did I miss? I mean, what is clear when you step away and come back is that Trump's won. Maybe winning is the better verb tense. And it's not just that he delays. It's the audacity is never matched. The asymmetry of the 26 campaign was that Trump was willing to do things so disgusting and abhorrent. Talk about blood coming out of Megyn Kelly's. I mean, the things were so gross that there was never a political comeback. He's now adapted that to his legal framework, and there's never a government response that results in anything other than Trump checkmating the Chutkan trial, Trump checkmating the Mar-a-Lago case, which is so open and shut that you can't get between Bill Barr and a camera when he's talking about this, because he wants to tell everyone Trump is done. And I'm back, and I know what SEPA means, thanks to Brandon and Mary, and we are so lucky to talk to them, because if you want to know what Jack Smith is thinking and doing, Jack Smith thinks and does what Brandon and Mary would do. But what's clear is that on a wing and a prayer, Trump faces accountability, and the American people see the evidence adjudicated by a jury of Trump's peers. On a wing and a prayer, that happens before November.
Yeah, Nicole, the verse, the wheels of justice grind slowly but exceedingly fine. We're all feeling the slowly, right? I think that's what you're articulating, but we're not seeing the exceedingly fine part. If anything, we're seeing a bit of obstruction, even with those wheels of justice, in part, large part, because Donald Trump as a defendant is offering these very audacious arguments, but it is all part of the most audacious strategy of all, which is to return to the White House and grant himself absolution, to ask voters to give him political absolution. And part of that strategy is to forestall these proceedings as long as he can. I think in the Mar-a-Lago case, Mary's exactly right. We almost just need to assume that case is going to slowly become irrelevant, either because Judge Cannon is willing to do Donald Trump's bidding, or she's just intimidated by the moment. Relatively new to the bench, there are more high-profile cases, and she's afraid to kind of take the lead. Whatever it is, it's clear in the Mar-a-Lago case that one's being drug out. Look, in the Jack Smith January 6th case, the Supreme Court now wants to drag that out as well, but there's still a scenario where we could get a bomb of a verdict, kind of as the October surprise, or it is such a pregnant question that it becomes the question for voters in November. I think the most intriguing part are the state cases that are beyond the reach of federal absolution, that there actually is nothing Donald Trump could technically do, even if he is reelected. That's where the Bragg case and the Fani Willis case come in, and you're seeing what they're trying to do in the Fani Willis case. We don't know. As America, if you are on the side of democracy and want to protect democracy, you get one vote and you got a voice to get your neighbors out to vote with you. We can't rely on the court system, but I would suggest that the wheels are still grinding, just very, very slowly.
And let me be clear, I don't know that there's anyone that does what I have a privilege of doing every day, more interested in or who admires more the people who do the hard work of trying to apply some sort of legal accountability to someone like Donald Trump. But I think since the first day of his presidency in covering those clashes with then FBI Director Jim Comey, to 23 months of covering the Mueller probe and the efforts to undermine the credibility of the investigators and the actual substance of that investigation in volumes 1 and 2, what is clear is that it is an asymmetrical contest. It is not proven possible for the rule of law to catch Donald Trump committing crimes increasingly in a brazen way. And I wonder, Brandon, how that lands, whether that's clear to your former friends and colleagues inside the Department of Justice.
You know, I actually would quibble with that characterization.
Please do.
You have a Department of Justice. You know, I like to argue with you, Nicole.
I love it. That's why you're here.
You have a Department of Justice that has charged a sitting president with 2 separate, a series of crimes in 2 separate districts. Like, that is a Department of Justice that is doing everything in its power to hold an individual accountable for those actions. That is not, there's arguments sometimes of delay investigation. Those are significant, unprecedented steps in terms of accountability. You're also seeing in those 2 cases, the Department of Justice doing everything it can to bring those cases as fast as they can. In the Mar-a-Lago case, special counsel's office, not just in terms of the dates, but in terms of how they've been responding to the judge's request and motions, they have done everything they possibly can to have these cases tried before. And so I do think whether or not those cases occur, I still think they are remarkable. And even if they don't come to completion, the allegations themselves are remarkable. And I do think it's worth noting in terms of the hearing today and where we are. Really, what we've learned from the filings today in the Mar-a-Lago case is this case can happen this summer.
Yeah,
I know that the former president's attorneys did a little bit of a bait and switch in terms of its August date, but the truth is this case can happen this summer. The question ultimately is whether the judges will press the parties to have the case this summer. But that is certainly sort of my takeaway, I think, from the hearing.